Good morning, everyone. Thank you very much for joining us. Despite the name on my tile, I'm actually not Justin Luckman. I'm Ali Tabari. I'm one of the barristers at St Philip's Chambers. And we've also got Kirsty White, who's also a barrister at St Phil's. Kirsty's got an interesting perspective on the discussions that we're going to have a little bit later on about taking instructions from client, because of course, Kirsty, you spent how many years as a solicitor?
I was actually an in-house barrister, and I spent 4 years, no, just shy of 3 years as an in-house barrister.
Fantastic. So Kirsty's got a bit more coalface experience than people like myself, and she'll be able to, I'm sure, offer some insights into how all of this is going to work. Right, what I'm going to do is I'm going to share screen and we'll go through the slides. Fingers crossed for the tech. Let's see how this goes. Okay, hopefully you can all see the title slide, new rules on witness statements. Now you're obviously here because you would like to draft a witness statement in business and property court proceedings on or after the 6th of April this year. What we're not going to do is we're not going to walk you through the practice direction and the statement of best practice, because actually it's quite a short read. The two documents together are only 13 pages long and it's available on the Gov website. And it's actually written in quite plain English. So on the basis that you could all read it yourselves and don't need us to do it for you, we're going to do something a bit different. We're going to go through a witness statement, which is from a real case. Obviously, the names, as you'll see, will have been slightly adapted. We're going to try and show the practical effect of these new rules and what we think the revised version of those witness statements should look like. What we're also going to be discussing at the end is what we think these new rules are going to be meaning for trial length, budgets, negotiations, client relationships, and so on. It is really just our best guess of what the witness statement will look like. Obviously, you'll have your own views on it. Now, as we go along, you'll see that there's a Q&A button. Please feel free to fire some questions through to us as we go along, and whoever's not speaking at that time will try and pick it up for you, and we'll answer it as we go. So I should say before we begin, I am generally an optimist by nature. I think these new rules that we're going to be going through, they mean well, but I think it's a bit of a sledgehammer to crack a nut. I think there are other ways of doing it that don't make life quite so tricky for lawyers and potentially for judges as well, as we'll see. There's also the thing where I wonder how any litigator ever survived before 2013, because this is the latest in a long line of culture changes. Before all these culture changes, what were we all doing? Of course, we had cost budgeting in 2013. I think it's fair to say that took quite a few years to settle down. We had Mitchell, we have a supplement to the White Book about that thick, just to do with costs. And even now, judges and lawyers and so on take still pretty inconsistent approaches to cost budgeting. And then we've got the second of the culture changes, the good old disclosure pilot. How's that going for everyone? I presume it's lowering your costs and narrowing the issues at every turn. And now we've got this culture change on witness statements. We've been told that we are over-lawyering witness statements. We're obscuring what the witnesses are saying and could ever say. And to some extent, that's probably right. But we'll see in the rules that perhaps it might have gone a little bit far and with some unintended consequences. Now, this is, of course, a pilot scheme, but let's not be under illusions. It's here to stay in one form or another. So I suppose we may as well get used to it. I think this talk probably is going to take 45 minutes, depending on how much Q&A we get, but we'll certainly get through the meat of it in 45 minutes. So you'll be back at your desks probably by about 10:20 at the latest. Right, Kirsty.
Okay, so as Ali has said, this is a short practice direction. It's only 13 pages long, and you'll find it at PD 57AC. Very straightforward to read, but we'll just run through some of the key points and pull them out for you. Now, this is an initiative that started as something for the commercial courts, where they were finding that the witness statements were over-lawyered, but it's grown legs and it's developed, and it's going to be used in the business and property courts. Having said that, there are some exceptions, which I'll come on to in a few moments. And and it will come into force for witness statements that are filed on or after the 6th of April. So I'm sure you've all diarised your directions for witness statements, but now's the time to go back, just check when they're going to be filed. And unfortunately, for those of you who have progressed through perhaps to a final stage of a witness statement, final draft, I'm afraid if it's filed after the 6th of April, you're going to have to go back and have a look at it in conjunction with this practice direction. It does only relate to trial witness statements. So if you're making an application, this practice direction doesn't apply. And as I said, there are some exceptions. It doesn't apply to insolvency proceedings, trust and probate claims under CPR 57. And there are others in there which are at paragraph 1.3 of the practice direction. One of the others are, it doesn't apply to certain Company Act claims either. If there is a discrepancy between this practice direction and some of the specialist court guides, so the Chancery Court Guide, the Technology and Construction Court, then this practice direction takes precedent over those. And one of the things Ali and I have had a bit of a laugh about over the last few days is that this practice direction applies to litigants in person. Very best of luck to any judge who's going to try and enforce a litigant in person, not putting any legal argument into their witness statement and not commenting on documents. We await with intrigue as to how that's going to progress with litigants in person, I must say. Okay, and alongside the practice direction, what we've been given is a statement of best practice. Essentially, it's a practice direction for the practice direction. Ali, I don't know what you thought, but when I read the statement of best practice, it doesn't really expand that much more on the practice direction. It just repeats itself in slightly different language.
Pretty much.
Yeah. Now, the guidance that we're given is that trial witness statements should be as concise as possible without omitting anything of significance. And also that it should set out the factual evidence which the witness could give if he or she were being examined in chief. Basically, what they're saying is, we don't want to see legal argument, we don't want to see hypotheses, or we don't want to see someone's interpretation of a document that they had no involvement in trying to argue this case. We want you to do what we asked for witness statements to do way back when, and that is set out evidence that that particular witness can talk about from their personal perspective because of their involvement in it. And you'll be pleased to know, after we had a new statement of truth last year, we're going to have another one, and it's going to be expanded, and Ali and I will show you what that will look like further on through this talk. But essentially what it's saying is that you, as a lawyer, the solicitor who's taken this witness statement, have explained the practice direction and what this practice direction is trying to achieve, and that has been understood and complied with, and they will sign that statement of truth.
It's a real whopper. We'll see it at the end. Right, well, should we have a look at this case study that we're going to be dealing with then? It is Johnson Electricals, who's the claimant, and they're bringing a claim against two defendants, Euroblock Limited and Mrs. van der Leyen. Mrs. van der Leyen is the director of Euroblock. It's a £1 million claim in the commercial court for breach of contract on the basis that Euroblock has failed to pay a bunch of invoices, but also a nice little twist, a fraudulent misrepresentation claim against the director. Because what happened was they ordered a whole load of electrical goods, they didn't pay for them, and the claim against the director is on the basis of that, if anyone's read that Context Drusba case from a few years ago, the case against the director in fraudulent misrep because she knew that the goods could never actually be paid for at the point where the order was placed. The defence is being run by the first defendant is that the person who put in the order had no authority to bind the company. They also say, standard, defective goods were supplied, so they don't have to pay for them anyway. And the director says that there was no fraudulent misrepresentation. So let's have a look at Barry Johnston's first witness statements. Kirsty.
Okay, so what we might expect to see at the start of a witness statement, Mr. Johnson is setting out he's a director of the claimant. He makes the witness statement in support of the claim. And then this is the bit that we've had to add as of last year. I've made this witness statement by meeting with my solicitor and discussing the matter with her. And I approve this version of the statement by email correspondence. I am now shown a bundle of documents which I refer to as, and then we have the exhibit number. Now, we'll see when we move on to the next slide that actually what now needs to happen under the practice direction is there's a slight amendment to setting out how this statement has been obtained and what documents have been shown. So what you'll now need to make a note of in a witness statement, for example, is how have you met with the solicitor? How have you shown the bundle of documents? Was that shown when a witness thought about it, or were you showing those documents to the witness in advance? So solicitors, you're going to have to take a much more detailed note. And when you're asking those questions, as I'm sure you all do anyway when you're chiefing a witness for witness statements, it's really important that you think about how you're phrasing questions. Are you asking open questions and getting the witness to tell you their version of events before you ask more close questions? Are you leading with any documents, or are you waiting for a witness to introduce them to you? Now, this new sort of practice direction, you as a solicitor, you should be there helping with the structure and layout, but not necessarily sat there proposing content. What about this scenario? What about this document? Can you comment on this? It should all very much be witness led, and perhaps to a certain extent is leading to an era where we might say, well, actually, you as a witness, why don't you go away and write your story, and then we'll have a look at it afterwards and we'll put it into some sort of witness statement. So with that in mind, Ali, if we could have the next slide, please.
You have to give me a Chris Whitty style next slide,
yeah,
please.
Sorry.
There we go. Yeah. There we are.
So Ali and I have amended this to then say, give a bit more detail. I made this witness statement by meeting with my solicitor on 2 occasions via Zoom and discussing the matter with her. I approve this version. In order to refresh my memory during those meetings, I was shown documents 1 to 17 in the claimant's disclosure list.
Kirsty, can I ask a question at this stage?
Yeah.
We had a question in advance from a very organised delegate who wanted to know whether lawyers here should take a staged approach. And the question was, should you have, for example, a first interview just with no documents at all, and then maybe a second interview where you introduce some, that kind of layered approach? What do you think could be the ups and downsides of doing something like that?
Yeah, from my experience, if you've got a witness who's key and lived most of this, you tend to find they do remember the pertinent documents. So if you go in with that approach of, as I say, you tell me your story and then we'll have a look at some documents, you are being witness led in that instance, because you may have already identified those documents that witness is then suggesting you look at or what recollect with their memory. If the problem, I suppose, comes if you've got witnesses who are less forthcoming with their evidence, they do need a bit more prodding and they do need a bit more invitation to be engaged in the process, or they've just got a terrible memory. I do think as long as you've led that very open discussion at the start, tell me your events, tell me what you remember, and have tried to gain as much as you possibly can from that witness, I think, yes, then you do go on to that layered approach of, okay, when we met last time, you told me about, you could remember a meeting. It looks like these are the minutes of that meeting. do you want to go and have a look at those, and just hand them over to the witness rather than trying to ask them questions. Wait for them to have a look at it and tell you what they want to tell you about it.
Aren't you then going to get some cheeky barristers in cross-examination saying, well, hang on a second, Mr. Johnson, my witnesses only had to look at 2 documents to remember clear as a bell what was going on. What's wrong with your memory? Why are you looking at 17? Are you really a reliable witness? Can you tell us accurately?
I think you will get that. But as I say, I think we all sit there as barristers and say to witnesses, and we've seen it in cross-examination as well, where people clam up or they remember things slightly differently. I don't think there's anything wrong with the witness saying, well, I did have to refresh my memory slightly more than, say, somebody else. As long as they can set out the process of how they were shown those documents. I spoke to my solicitor, I remembered a meeting, but I couldn't remember exactly what we spoke about. And that's when I looked at this document. I don't necessarily think that's a problem. Do you, Ali? Do you think that's...
I think with everything, it's about the process, isn't it? If you've taken a proper record of things, it's not a memory test giving evidence necessarily, but if it does look like a lawyer has over-engineered this witness statement and has thrown thousands of documents at a witness before they come up with the right answer, then that's going to be a cause for criticism. But generally, in cross-examination, you can work out which witnesses actually know what they're talking about and which don't. But what we'll do is we'll move on, because we're going to be talking about the types of documents that these witnesses are going to need to see anyway. And there's a difference between perhaps some of the documents that witnesses will have been shown so far and the ones that under this new practice direction they'll be able to. This is a nice little intro to a witness statement that you tend to find. Claimant was incorporated in 2001 under company number. You can read this for yourself. It's not enormously interesting or indeed relevant, because I think the practice direction says that if something doesn't need to be said in order to prove the facts that this witness is speaking to, you can just get rid of it altogether. I don't think anyone would lose anything by not hearing about the thrilling comings and goings of classes of shares over the years. So this is probably what it looks like under the new rules. The claimant was incorporated in 2001, since incorporation, I've been a shareholder and director. I don't think anybody really needs to know any more than that, do they? But then there's the contrast with this next one here. Just before I go on to it, a couple of people have asked if the slides are going to be available afterwards. That's fine. We can email those to you. So if you want to take notes, please do. Otherwise, just sit back and watch. The next part then of Mr. Johnson's witness statement goes on to talk about what type of work the company does, but also the growth. Growth not just in terms of turnover, but in terms of its employee numbers. And you can see at the bottom of the paragraph 9 here, it talks about all of the fancy appointments and jobs that it's got over the years. Now, again, you might think, is this just like the last slide? Is this really relevant? But actually, part of your case, if you're for the claimant, might be to say, we don't just deal with anyone. We're not wet behind the ears, brand new to this game. We undergo due diligence, and we know the difference between somebody who's authorized to bind a contractual counterparty and a charlatan. And so actually, it might be important to put this type of context to say, we are a big business, we do know what we're doing. And so it makes it all the more egregious that Mrs. van der Leyen has done this to us for the fraudulent misrep claim that you're bringing. So maybe it stays as it is, but you might find another, perhaps more explicit way of putting it. You could actually just say, rather than going through the potted history of the claimant business, you could just say, we're a big business, here are some documents that prove it. As a result of that, I'm confident that we knew what we were doing with our due diligence process and also with our credit control. So that's a different way to skin that particular cat. Let's go on to this one, Kirsty.
Yes. So here what's happening is we're having it set out to us how we entered into correspondence and what the purpose of that correspondence is. There's a reference there to an email. Mrs. van der Leyen emailed me stating that her company had a requirement for a large outdoor venue. Well, if it's obvious from the disclosure list and it's been shared that that's been there, there's no need at all to write this out. If the document can be seen and a judge can read it for themselves, why are we setting this out? And this is what the practice direction is trying to get us to move away from. I'm sure we've all seen witness statements where a witness has referenced an email, set it out, and then has given their view on it underneath. Completely not necessary, and the practice direction forbids this from happening. So Ali, if we just go on to the next slide. Again, we've just changed the wording to what we think it should look like. So which are evident from the emails initially between myself and Mrs. van der Leyen and later. And then we've identified where they are in the disclosure list, so the judge or the advocates can go and look for themselves rather than unnecessarily lengthening a witness statement. Okay, and there are some other areas that the practice direction forbids us now from commenting on. So again, here Mr. Johnson is setting out that Mrs. van der Leyen then dealt with his colleague Priya Patel, and there is a series of emails that then went between Mrs. Patel and Mrs. van der Leyen. Now, what the practice direction says is, unless Mr. Johnson is copied into those emails, he can't comment on those. It's a document he didn't see at the time it was created, and so it's not evidence that he can now give. So again, Ali, if we now go on to the next slide, he can say, I understand that the defendant then placed orders with the claimant. I had no personal involvement with that. Here you will notice we haven't actually referenced where they are in the disclosure list, because one would expect if Ms. Patel is giving evidence, she will then note in her witness statement where they are, where those documents are, and where they can be found in any disclosure list. So it's just not necessary to happen in this witness statement.
So this looks like it's the end for those massive sort of compendium witness statements from a corporate client, where you have one person, say an in-house lawyer, going through the whole thing, and then when you ask them questions and say, well, what did this email mean? They'll say, well, I don't know because I wasn't copied into it. You'll have to ask Ms. Patel, but you know, she's not listed as a witness. So it might mean more witnesses giving smaller chunks of evidence rather than one person giving it all.
Yeah, Ali, on that, we've just had a quick question. And what if Ms. Patel isn't giving evidence? Well, then I think in that instance, we could say those documents can be found at 1 to 2 of the disclosure list, but make no further comment on what they say.
Absolutely. Let's just take a quick pause here and answer a couple of questions which have come through. Andrew, you've asked, what are the sanctions for non-compliance? If you hang around for a few minutes, we will get there at the end of this witness statement, I promise. How do you one of the questions is, how do you think these changes to witness statements will place even more onus on disclosure and the use of disclosure lists? The format isn't great depending on who produces them. I think that's a very polite thing to say. It may be unclear what each witness actually has reviewed by listing documents 1 to 17 in the disclosure list, for example. I think on this one, it kind of goes back to that utopian vision of what disclosure looks like, where both parties sort of hold hands and skip through the disclosure fields together and say, we can agree all of this and it's all fine, and here's a single list for everyone to refer to. It may be that you just have to refer to your own disclosure list, and then there'll have to be some reformatting as time goes on, just in the same way as you have with trial bundles at the moment, at least until disclosure settles down and this settles down at the same time. That's probably more likely to be measured in years than months, I would guess. I know there are some other questions coming through. We will deal with them, I promise. I'd just like to make sure that we kind of whip through this statement so we can tick off all of the key points from the practice direction before we then come on to this. Now, this is something which I think really the practice direction is really aiming for. This is the bugbear. I'm not going to read all of this out, but paragraph 17 and 18 here is Mr. Johnson telling us what it looks like van der Leyen did, what her colleague Matthew Barnier did, what conclusions we can draw from the fact that his email signature said senior logistics director, etc., etc. I think this is what everyone does or should do anyway, which is leave all of this out, because this just isn't the job of the witness. This is, in fact, two no-nos in one slide. The first is making legal submissions. One of the main drivers, as I say, of this reform is to make sure the witnesses just give evidence on what they saw and heard. You're likely to enrage a judge by going outside of that. The second point is, if you look at the language that's being used here, particularly in paragraph 18, unless Mr. Johnson actually speaks like this in real life, the strong encouragement from the practice direction is to use the witness's natural words. I've not found too many guys who own electrical wholesalers speaking as if they're from some sort of Victorian court of chancery like this bloke is doing. So don't be afraid to kind of cede control a little bit. I know as lawyers, we do like to tightly control what's said, just in case there's a word out of place here and there. Going forward, judges are going to expect witness statements to be written in pretty much the same type of language as they hear the witness give. So I think what this should actually look like is this. Just says, I understand the order was placed by Matthew Barnier, the senior logistics director. I had no personal dealings with him. Maybe a way of getting to the point of ostensible authority is to say, well, nobody in my team asked me whether there was a question about their ability to deal with him. I don't know of any such conversations between other team members. That might be evidence that Mr. Johnson could give, and it might go to the point of saying, well, if no one's raised an issue about it internally, that probably suggests that we reasonably relied on this chap's authority to bind the first defendant. But that's something that the advocate brings together in the closing submissions at the end. Kirsty.
So again, I'm not going to read all of this out, but the key point to pick out here is that what Mr. Johnson is now doing is referring to a particular email on the 21st of November, and she wrote to Miss Patel as follows, and then has literally just copied and lifted words straight from that email and put it into the witness statement. As we said earlier, witnesses are not to quote at length from documents if they're available in the disclosure, and they can be simply read by the judge and anyone who needs to. So what we propose this would now look like is it wouldn't exist. It would be completely blank, and there would be no need to put anything there. So I suppose where there are certain key documents that we might want to pull out, that might be something that then is appearing more in a skeleton argument, or if you have a chronology and that date is particularly important and the email supports it, a reference might go into that chronology. So it's for the advocate, I suppose, to pay a bit more attention to key documents in those documents rather than witness statements.
And much on the same sort of lines, this is the bit where Mr. Johnson tries to demonstrate that when Mrs. van der Leyen was having the orders placed, she couldn't have had a reasonable belief that Euroblock would ever be able to pay for it. And so what he does is he goes through all of the company's house records and he pulls out some numbers and he says, well, there we are. She couldn't honestly have believed that she'd be able to pay the invoices, etc., etc., etc. Now, this reads like a pretty incisive skeleton argument, but of course, it's not evidence that the witness could give. To comment on the case, the practice direction says explicitly that's a no. Also, it's talking about documents to which he wasn't privy at the relevant time, unless he was sitting there talking to Mrs. van der Leyen or emailing her with the company's house records on the side. It's not documents that he's entitled to give evidence about now. And it also goes back to that point of commenting on documents which could simply be explained by reading them. So once again, I'm afraid this is another blank, let's leave it all out entirely. Now, of course, we haven't gone through the whole of the witness statement here. There are other parts that are going to be in there, particularly to do with quality of goods and so on. But hopefully what you can see there is that the sort of standard stuff which tends to crop up in commercial cases, witness statements, actually are going to be significantly cropped down. That's going to have a good effect in the sense that the witness is only going to be confined to the type of factual matters that they could give evidence about without having to guess. But what it also does is it has a few unintended consequences that we'll come on to very shortly. But first, Kirsty's going to take you through that wonderful new statement of truth.
Ali, just before we get on to that,
yeah.
Just an interesting question for you. If Mr. Johnson was a financial director, for example, and he was used to seeing those accounts on Companies House, would your view change as to whether he could comment on those in a witness statement?
I would say he probably still couldn't, because if you can imagine trying to say to a witness in examination in chief, you know, Mr. Johnson, well, you've seen all this. Well, what do you think about it? What's the first thing that's going to happen? The judge is going to jump in and say, don't really care what this guy thinks about it. Actually, I'm the one who decides. I'll hear submissions about it later, but can we just stick to the facts?
Okay. Yeah, and I would agree with that. I just thought it'd be interesting because you do get in commercial cases quite often witness statements from financial directors or accountants. So just useful to know your thoughts on that.
Yeah.
Okay, so I'm sure you'll all be familiar with what the statement of truth now looks like. It's a nice 4 lines, and here is now what it looks like after this practice direction. As I said at the start, it sets out that the practice direction has been explained to a witness. Importantly, it says, I have set out matters of fact which I have personal knowledge. I understand it's not my function to argue the case, and it's not, or to take the court through the documents. It sets out only my personal knowledge and recollection in my own words, or on points that I understand to be important to the case. I've stated honestly how well I can recall matters and whether my memory has been refreshed by considering documents. So what has gone from a very short sentence 14 months ago, we are now here at something that looks like this. And then, Ali, if we go on to the next slide, because we haven't finished with compliance with the practice direction. As if it's not enough that the witness signs to explain that this has all been explained to them and they've given evidence in a particular way, solicitors are now going to be asked to sign a certificate of compliance. And we've set out the wording here of what the practice direction is looking like. So you're the relevant legal representative, you've explained. So essentially what the court is doing is double ending it to make sure the witness is saying they've complied, and also the solicitor. But what happens, and Ali and I have had a discussion about this yesterday, what happens if you get a witness who isn't happy with just stating the facts and they just want to say, well, no, this is what this clearly demonstrates and this is what they were thinking about, and I want that in my witness statements. And I think our view is it's going to cause problems for you as a solicitor in being able to sign this certificate of compliance. If you don't think that that witness statement now complies with the practice direction, you can't sign this.
Can't you just jump off the record while they're writing it and then come back on a bit later on?
Wow. I don't think so. I don't think that's going to happen, is it? And I also call into question whether the witness could actually sign now that statement of truth. If they're saying, I am not commenting on things I don't know about, well, actually, it's going to trip them up a lot more. And I think, again, you'll get advocates when they do the trick of, you signed a statement of truth and you've said that everything is honest, but that's not true because of this document. You're now going to get the question in cross-examination. You've said you haven't commented on things you didn't know about, but that's not right, is it? Because here we are at paragraph 15 of your witness statement. Where are you in that email? Why are you commenting on it? And it comes down to this: we can all advise clients of what to do, but ultimately we get caught between that rock and hard place where it's only advice, it's not orders. And so we could have some very tense conversations between solicitors and clients in the near future, I think.
Well, let's find out what happens when we don't follow the rules. The sanctions. You've had your awkward conversation with the client, and part of it has to say, well, here are the things that the court can do if we don't follow these practice directions. The first is you can strike out the witness statement. This can be done of the court's own motion or on application. In reality, how likely is that to take place? It's just like trying to strike out a claim. It's a port of last resort. So I don't imagine you're going to be seeing too many instances of that taking place. Requiring the witness statement to be redrafted. Now, you can't imagine that's going to happen at trial. So there has to be this pretty swift application made after receiving the other side's trial witness statements and saying, hang on, this is completely out of kilter with the practice direction. Make an application to the trial judge, or you do it at the PTR or at some point like that. And the application has to be, presumably, strike out the witness statement or order it to be redrafted. There's now potentially going to be a whole lot more work at a PTR stage or leading up to a trial from people saying, well, I'd like to strike out that part and I'd like to strike out that part, and getting it in front of a judge who knows what the case is about and is going to be able to do something about it. Again, it's one of those potentially unintended consequences of the court could actually end up creating more work for itself, because people will be quick, as everyone is, to jump on these new rules and point the finger at opponents who aren't doing it right. Potentially, if the witness statement is to be redrafted, query whether that constitutes a significant development for the purposes of cost budgeting. Could you go back and say, we thought we were going to have 15 hours on witness statements, we've had to do it again, so can we have 35? Probably the answer is going to be no, but it's an argument to be raised. What the court can do also is it can disallow the cost of the witness statement. My guess is that's probably going to be the most likely sanction for the more serious breaches here. I think a judge will still want to keep a trial running, keep things in the list where possible. And if it's cost sanctions, then that's probably the most likely outcome. The final potential sanction is this, and this is a massive careful what you wish for type of moment, I think. The court could require the witness to give evidence in chief at trial. Now, I was fortunate enough to spend the first 3 years of my working life doing criminal defence work. And I can tell you now, from an advocate's point of view, chiefing your own witness is every bit as difficult as cross-examining somebody else's, because you just don't know what they're going to say. And half the time, they're not telling the court what they told you 5 minutes before you went into court or last week when you met them in conference. It's a real advocate's skill to be able to get a witness to tell the right story in their words. It's not just a case of let them off the leash and they'll tell you, everything you need to know. It's not like that at all. And often, of course, it takes longer. So if you've got your 4-day trial estimate and you kick it off and the judge says, well, I'm not happy about this witness statement. I don't think it complies with the practice direction. I don't think it's the witness's evidence, really. I'm going to require them to give evidence in chief. Your 4-day time estimate is now just blown to smithereens. You might not finish the evidence by the time you get to the end of 4 days, depending on how interventionist that trial judge is. Are they really going to do it? Who's going to take responsibility for the runover? And actually, when you look at the structure of a witness's evidence, the moment it starts to be given in chief rather than on paper, you're creating a whole host of problems, potentially with a whole bunch of advocates and judges who've never really had to get skillful at examining in chief, because at the moment it's just 4 questions, isn't it? Is that your statement? Have you signed it? Is it true? Things to watch out for. So the practical effects. Well, I've mentioned cost budgeting already. For a witness statement phase there, let's imagine it all goes right and you are doing your witness statements in line with this practice direction. Are you going to be spending more time with the witness, or are you going to be spending less time? Because in some ways you could say, well, look, it's going to take less time because the lawyer doesn't have to sit there pre-planning all of the questions that are going to ask, the avenues they're going to lead the witness down. But is it then going to be more time? Because actually you have to try and get the witness, right? No, we're actually talking about this. Let's come back to this point here. That type of process, I think it might just be trial and error. But the next few cost budgets that you have, once this direction comes in, you can imagine you may as well toss a coin as to whether you're going to be spending more or less time on this phase. I've then said longer opening speeches mean longer trials. The number of comments and so on I've seen from senior judges and people sort of high up in the profession that say, oh, we get to go back to the good old days of opening a trial properly. I think, but isn't the point of trials these days to try and keep things measured and short and proportionate? Barristers don't need an excuse to waffle on for longer than they need to, but if you say to them, instead of just the judge coming in saying, I've read everything and don't need to open, let's get on with the evidence. You can't have witness statements like that anymore. You've got to turn up as an advocate and actually open the case, potentially at length. And that's the point at which you take the judge methodically through this document, and then that document, and then that document, in a way that simply couldn't have been there in a witness statement. So any money that you might have saved on a shorter witness statement phase, you might just be kicking the can down the road, because your trial estimate is going to have to be half a day or 1 day longer to account for longer openings. And that's probably going to affect the trial prep phase, because we're always told to keep our skeleton arguments skeletal. Not so much anymore, because of course you can't just say, read the witness statement and it'll tell you what you need to know. You'll have to take the judge most likely through all of these key documents. There's going to be page after page after page. And potentially you could try and strip some of that out by having an agreed statement of facts decided between the parties beforehand. That was one of the proposals in the initial commercial courts consultation for this. They decided not to put it in at the end. But anyone who's tried to agree a case summary or a list of issues with your opponent recently might say that actually getting to an agreed statement of fact is easier said than done, probably going to stretch out a bit of time and cost in the pre-trial phase. And of course, the pre-trial phase is going to involve prepping your witnesses a little bit more than saying, have you read your statement recently? You're going to need to really go through the evidence with them and ensure that they are genuinely fit to give the evidence that you think that they should do and will do. Final thing we thought about was the impact on negotiations. And sometimes you do have a witness statement, which is, both barrels. It goes absolutely, full bore, trying to pound the other side into submission. And sometimes it works, because you get witness statements where the other side, will read it and say, right, the game's up. They're going to hammer us at trial. Let's get on and negotiate. You're not going to have that anymore. So is this going to have the unintended consequence of fewer cases actually settling in the period between witness statement and trial, because you won't have one side being bludgeoned over the head with the strength of the other side's case? Again, we'll have to wait and see. I mean, Kirsty, how do you think this is going to work overall? Good, bad, or ugly?
It's definitely going to be ugly, I think. Yeah. I think it's a hold our breath moment and see what pans out, really. I think some of the observations that you've made in terms of, particularly if a witness statement doesn't comply, and a judge says, well, I want you to chief your witness. I don't know. Something tells me a judge wouldn't quite be that harsh, because we're going to have this period, as you say, of, well, what will happen to trial length? And we're already in a massive backlog, aren't we, of cases. So I don't think we'll necessarily see that. This is just my personal feeling. I don't think we will see that sanction, but I think you will see more applications of people trying to strike things out in witness statements. I think from a solicitor's point of view, it's going to be very difficult, because for many, I think it will change the way you ask your questions of witnesses and those initial meetings. In the observation, in the question, someone's actually said, well, we take our instructions from a witness, or we devise a witness statement over a series of meetings with that witness, and we go through various things. And in some instances, a principal witness has actually had a hand in particulars of claim or a defence or Part 18 requests. So that could potentially taint how someone's going to view a particular document, or taint how they'll remember things. But I think it does go back to this age-old saying of, we may all live a scenario, but actually we might remember it slightly differently. And I think this approach in the witness statement and the changes is going to draw that out. So I think it's going to be a good thing to get away from legal argument, because there's nothing more frustrating as an advocate when you get a witness statement which has argued a legal point and you think, well, that's not quite how I would have expressed that in my skeleton argument, and you're sort of bound by that. So I think if we can get witnesses to go back to just factual evidence, it will be good. But as I say, I think it will be a hold our breath and wait and see moment in many respects.
Absolutely. Right. Everyone who's clear on everything so far and doesn't have any questions, this might be the time where you can click off and have a good rest of the day. We've got some terrific questions on the Q&A, which we're going to try and answer as quickly as we can. So I'm just going to go in no particular order.
Popped up quite a lot, and that's in respect of the statement of truth being applicable to the exempt areas that we identified at the beginning. My view is, if it's exempt, then perhaps you don't need that lengthy, because it's saying that it has been explained to me, I have complied in a particular way, I haven't set anything out. So I think you can just rely on the old statement of truth.
Yeah, absolutely. And one of the questions which has come up a few times is essentially to say, yes, this is only for trial witness statements in the BPC. Should we be doing it elsewhere? I think it perhaps goes back to the beginning. This is going to be here to stay in one form or another. There's probably nothing wrong with at least giving it a good bash if it's a county court claim. Have a good go at following the practice directions, safe in the knowledge that the sanctions that are there won't be able to bite on you if for whatever reason you get it wrong. So let's see what other questions. There's a few questions about how do we then deal with the documents that the witness statements are then referring to? Do we just exhibit them to the witness statements and so on? I think it's just a case of how you mark those documents up and can you find them in the trial bundle. So I don't think you necessarily need to have them as kind of witness statements, exhibit, witness statements, exhibit, if what's going to happen is there's going to be lots of duplication. So it might just be a case of being a bit more organized. There's nothing in the in the practice direction that actually tells you how to deal with it within a trial bundle. So you'll have this weird scenario where if you're doing it in the commercial court, the witness statement needs to comply with the practice direction, but the way that the trial bundle is set out is still in the commercial court guide. And so that may or may not give you the answer. It's going to be awkward, it's going to be fiddly, and I imagine this is one of the things which is going to change as time goes on.
There's one question that's come up, Ali, which might be interesting, an interesting point. Someone asked, and I can't now find the question, but someone has asked, if I've already drafted my witness statement and it's ready to go, can I file it now with the court to avoid the practice direction and then serve after?
I don't think that's in the spirit of it. I think you might get a little slap on the wrist.
I agree. I think unfortunately in that scenario, it's a very late redraft, unfortunately.
Just on the point of drafting, someone asked a practical question, which is about the way that you take your evidence, saying usually what happens is I'll take notes, I'll take attendance notes of meetings that I've had with the client over a couple of meetings. I'll then prepare a first draft and then send it to them and say, what do you think about this? Is this going to be permitted under the new rules? Can't see that that is going to be an issue at all. You're still doing what the practice direction says, which is allowing it to be witness-led. You're not proposing the content. All you're doing is sorting out the kind of the layout, the structure, and sometimes potentially the language and the typos and all of that kind of stuff, and keeping it on point. So I think if you do all of those things, it's pretty much in compliance with the best practice statement.
Yeah, I think the one important point there I would say is that sometimes when you're taking the attendance note, there can be a tendency for the lawyer to put it into their words more than would necessarily be. So just make sure with your attendance note you are capturing how the witness has actually said it, so you've got that to hand. Yeah.
A few questions about the type of documents that a witness can say that they've read and considered as part of giving their evidence. Someone raises, could the witness say that they've read the pleadings and so on? And someone else talks about correspondence to which they were copied in. Absolutely, they can put that as things that they have read in order to refresh their memory. But just using the example of the pleadings, it's all very well a witness reading the pleadings and then giving their evidence, but it doesn't mean that they can then give evidence about the things which are in the pleadings. They can only give the type of evidence where if you just sat them down and said, right, what did you see? What did you hear? What did you do? That's really the only material that they can give evidence on. So I think they're free to read what they want as long as you list it. You just have to be careful that it doesn't stray into what they're actually properly giving evidence about. Kirsty, have you spotted any other questions? There's lots of them.
There's lots. Just trying to deal with ones we haven't dealt with.
Oh, here's a good one. What if the witness is the person who's been giving instructions since the start of the case? Surely their recollection will have been influenced by this. Yeah, I think that's absolutely right. And a lot of the kind of the working group reports that have gone through this is to say, we do experience this differently. People's recollections, it's not just, the truth isn't just one thing. Often it is lived experience. Three people can look at an incident in completely different ways, even though they were seeing objectively the same thing. I guess our job is to make sure that the witness isn't saying, well, actually, in hindsight, now that, Mrs. van der Leyen did this, I can see that what she really meant was this, and what she was trying to do was that. That's really more the advocate's job. And it leads into one of the other questions, which is about the practicalities of the judge's interventions. If they've been told, just read the bare witness statements, don't go into the exhibits. Absolutely right. An advocate's job, and in fact, as a team effort, is going to be a lot greater in terms of finding those key documents that we want the judge to see at the outset. So you put it in the skelly, you raise it in your oral openings. Still, there are going to be judges out there who are going to read everything anyway, aren't they, before they get there? The ones who say, I've only read the witness statements, and then 10 minutes later, they're cross-examining your client about page 892Z that they definitely didn't read beforehand.
Here's a good one, Ali. And the question is, what impact do you think it will have on ADR and settlement if we now will not get the other side's position on key documents until skeleton arguments?
It goes back to that point, doesn't it, of saying if you've laid it out in your witness statements beforehand, you can say to your client, we've all been on the wrong end of a case where you just have to say to a client, look, if they come up to proof here, it's curtains for you.
Yeah. If
you don't have that, it's just going to be harder to have the conversation, isn't it? It's going to be harder to persuade. I mean, what might it mean for a mediation? If you have a mediation after witness statements but before trial, that whole thing of mediation advocacy where you turn up and say, listen, our case, this isn't the forum for doing it. Actually, there's a lot more impetus for saying, by the way, day one of trial is going to look like this for you now. Yeah. And then the mediator's got a job peeling everyone off the ceiling for the first 15 minutes or so. Let's have a look. Another question about skeleton arguments. Yeah, I'm afraid they're inevitably going to be longer. I hate long skeleton arguments. I hate them. But I think they're gonna be a necessity in BPC cases where the witnesses can't do some of the work for you.
There's a question about, will a standard certificate template be issued by the courts? Will the solicitors need to draft the certificate? I would say be prepared to create your own template for now. I haven't seen a court-issued form, and there isn't one mentioned in the practice direction either. So I would suggest you set up your own template.
Absolutely. Cracking question, this one. What do you do with a witness who is dyslexic or has difficulty expressing themselves in writing? Well, Kirsty, what do you think?
I think it comes back to, as we've mentioned, there's nothing wrong in doing a first draft for somebody. You have those initial meetings with that witness. I don't think there's a problem in doing what you would at this moment in time, the witness meeting with you and the solicitor drafting it. And I suppose in those instances, what happens is you are reading the witness statement to that person anyway, to make sure they understand what's there. I think what you could do in that instance is perhaps add a paragraph at the beginning of the witness statement to say, I am dyslexic and my solicitor has read certain documents to me, or has read back my witness statement to me to make sure I understand. So I think that's how you would deal with it in that instance.
And a really good point that's just been made in the chat is that it's potentially discriminatory for a judge to draw adverse inferences from someone who has a disability, for example, and can't express themselves properly. I'll just do a couple more questions because there's obviously loads of them and we don't want to keep people on the line too long.
Just very quickly linked to, in a slightly different way, but there is a question in the chat about what if English is not the main language of the witness, or the witness does not speak English at all. Then we go back to the rules in the CPR, and that witness statement should be in that person's first language and translated. This doesn't affect that in any way at all.
Yeah, absolutely. Couple of questions along the same lines of, what if you've done a witness statement for an interim application, an injunction or something like that, pre-new rules, and then you want to be able to rely on that later on when it comes to trial? Do you have to redraft it? I think the question is, if what you're going to do is you're going to transport all of the material into basically a witness statement and say, well, look at all of this stuff that I said before, I'm just going to repeat it. I think there you'd need to fillet it. I think you would need to redraft it in accordance with the rules. However, this is only a witness statement which only practice direction that applies to witness statements prepared for trial after a certain date. So I think actually you'd be perfectly entitled. I think you get a fair audience from many judges to say that was drafted back then, the PD wasn't in place then, it wasn't even for trial. We'll rely on it to the extent that you think it's appropriate to rely on it. And the judge just goes back to the first principles, which is this actually witness evidence that I can rely on, I can take into account, or is it just argument? And they'll probably just do the same process of filleting out what they can and can't rely on as they would ordinarily have done. I think it's perhaps, it looks more of a problem than it actually is. We'll just deal with one more at this stage, and then I think we'll end it there for now. Question is, what about if a witness decides to just read a large swathe of documents to remind themselves of the minutiae of a case? For example, a professional negligence case where a defendant solicitor says that he has a very clear recollection of something that he said 5 years ago, but he's actually looked at page 1 to 10,000 in the disclosure list. And then it ties in with one of the other questions that's been asked about whether adverse inferences can be drawn from looking at too many documents. I think the reality here is you're going to ask a question, it's going to raise your judicial eyebrow. There's no firm guidance on can adverse inferences actually be drawn. But I don't see why you couldn't say to somebody at the beginning, just plant that seed in cross-examination and say, are you sure about how good your recollection is if you've had to look at this many documents? I think it's a fair question. And as I say, a skillful cross-examiner will be able to get out over the course of time that actually somebody isn't really able to give the evidence that they say they can, or at least not with a massive amount of help. Right, well, I have to say that is the most Q&A I've ever had from any seminar ever. We should do everything virtually from now on, shouldn't we? Because it saves people putting their hand up. But thank you so much for all of those questions. If there's a question that hasn't been answered, or if there's something that crops up afterwards, you'll be able to find details for Kirsty and myself on the website. It's kwhite at st-phillips.com, and the same for me, Tabari at. Feel free to drop us a line with your questions. Otherwise, we'll try and send out the slides, because I think you all had to pre-register, so we'll have your details. So we'll send out the slides for you as well. Have a look on the Gov website. The practice direction, the statement of best practice is there. Any questions, feel free to come back to us. But otherwise, thank you very much. I hope you enjoyed it, and good luck with all those statements.
Yeah, and just to say, this recording will go on to St Phillips YouTube channel in due course. So if you want to go back and look at anything, then it will be there shortly.
Absolutely. All right. Take care, everyone. Bye-bye.
Thank you. Bye.